Woman's Health versus Hellerstedt. I'm Judy Grill, and this is Scholar's Mate. And welcome to Scholar's Mate. I'm your host, Judy Grill. In early March, the Supreme Court heard the case of Whole Woman's Health versus Hellerstedt, which involves safety regulations for abortion clinics in Texas. Supporters of the law say that these regulations are essential for ensuring women's health and safety at abortion facilities. However, opponents charge that the laws are intended to end abortion by closing abortion clinics. Joining us to discuss the case is Stephen Aden, Senior Counsel with Alliance Defending Freedom. He earned his JD from Georgetown University Law Center, graduating cum laude, and is a member of the bars of the U.S. Supreme Court and numerous federal, circuit, and district courts. He has also authored numerous law review articles on constitutional law and civil rights. He wrote an amicus brief in the case we're discussing today. Also joining us is Nicholas Little, Vice President and General Counsel for the Center for Inquiry. He holds a law degree from Vanderbilt University School of Law, in addition to a bachelor's in politics, philosophy, and economics from Oxford University, and a master's in industrial relations from the University of Warwick. In addition to overseeing the center's litigation, he provides general advice on legal matters affecting the center. He also authored a brief in Whole Woman's Health versus Hellerstedt. Gentlemen, thank you both for joining us today.
It's my pleasure, Judy. Thank you.
Thank you.
Steve Aden, could you please explain why the Texas abortion clinic regulations are necessary?
I'd be happy to, Judy. Thank you. Almost 25 years ago, the Supreme Court of the United States affirmed that states have constitutional authority to regulate the practice of abortion like any other medical procedure. And since that time, states have taken the Supreme Court up on that and have begun to regulate abortion more consistently as any other medical procedure is regulated. Prior to that, there were federal courts that were ruling things like, well, states couldn't restrict the practice of abortion to only doctors doing it. Literally anybody could do it under prior law. And then finally in 1992, the Supreme Court affirmed that states do have proper authority to treat abortion like any other medical procedure. And that's what Texas did in this case. It passed House Bill 2, which among other things had two provisions which are before the Supreme Court now. One of them requires that where abortions are performed, they be done in an outpatient surgical facility, like similar procedures like colonoscopy, endoscopy, LASIK, cataract surgery. All those are done in antiseptic, well-regulated clinical environments, ambulatory surgical centers they're called, and the law requires that they be done in Texas there, appropriate to the procedure. And second, that the abortion physician who performs the procedure have what are called admitting privileges, the authority to admit a patient to a nearby hospital in the event something goes wrong, which it does on occasion. In Texas, the parties agreed that it would happen about 210 times in any given year. A woman would be transported to the hospital for complications from an abortion procedure. So it's important that a doctor performing that procedure have the ability to follow up on complications such as perforating the uterus with an instrument, sometimes serious complications, and be able to admit her to the hospital and treat her there and take care of the complications there, which is what any other similar kind of outpatient physician would do.
And Nick Little, how do you respond to this argument?
Mr. Aden presented a very simplistic view of what this case is about. One thing he was right on is that 25 years ago, the Supreme Court made a decision in abortion matters. He actually only told you about half of that decision, though. The other half of that decision confirmed that in the United States, a woman has a constitutionally guaranteed right to choose an abortion before the fetus becomes viable. And in that period, there can be no restrictions on that right that are there to protect an interest in the life of the fetus. Any restrictions put in that period on the right to choose an abortion have to be justified by looking towards the health of the woman concerned. And in particular, the Supreme Court has been very clear that those restrictions are not allowed to place an undue burden on a woman's ability to exercise her constitutional rights. These restrictions these regulations are unnecessary. They do not provide women's health. They are simply a mask in order to justify an agenda, which is prevent women from exercising their constitutional right to abortion.
Thank you. Would you like to comment on that?
I'd be happy to.
Please.
We filed a brief on behalf of 5 medical organizations, which together comprised about 20,000 plus healthcare professionals, doctors, nurses, others, physician assistants. And in that brief, the members of our organizations informed the Supreme Court that what Texas did is simply standard of care for outpatient surgical procedures. It is basic to outpatient surgical procedure that if you or I go in, for example, for a colonoscopy or LASIK surgery or endoscopy, we would typically go into an outpatient surgical center, and the physician that does the procedure would have admitting privileges in case something goes wrong, and they can follow up at a local hospital and finish the procedure, take care of the patient. The only kind of outpatient surgery where this is not done very much in America is abortion. And that's because abortion for years was operating in a substandard way, even though the practice of elective abortion is identical in all relevant aspects to the practice of taking care of a miscarriage, what's called a dilatation and curettage. The procedure is identical except for dealing with a miscarriage, you're dealing with an unfortunate spontaneous abortion, and an elective abortion, what the patient desires is to end the pregnancy. But it's the same procedure. So if a physician, an OBGYN, is going to do a procedure for miscarriage, generally speaking, they'll do it in an environment like an ambulatory surgical center, and they'll have admitting privileges to take care of the physician. We did a trial in Louisiana last year involving admitting privileges, and the OBGYN who was testifying for the state was asked, how many OBGYNs do you know personally who have admitting privileges? And that physician said, well, I know about 20 personally, and every single one of them has admitting privileges to take care of emergent circumstances. It's just the standard of practice.
Okay, thank you. Do you have a comment on that?
Absolutely, I do.
Okay, please do.
Mr. Aiden is correct when he says the procedure this is most similar to is a procedure following an unfortunate miscarriage situation. Texas does not require that procedure to be performed in an ambulatory surgery center, unlike abortion, despite the fact it's the same procedure with the same risks. It does not require a doctor to have admitting privileges. And in particular, the main doctor who was put up as an allegedly expert witness to defend these regulations in Texas, Dr. Thorpe, who we wrote about in our brief, had to admit on the stand that he performs these procedures and he himself does not carry the admitting procedures. So it's another example of one law to do with abortion, one law to do with everything else. And we heard as well about these 5 medical organizations that joined the brief. Let's look at what they are. It's the American Association of Pro-Life Obstetricians and Gynecologists. It's the American College of Pediatricians, which is another anti-choice religious group which broke away from the the main pediatricians organization. It's the Christian Medical and Dental Association, the Catholic Medical Association, and Physicians for Life. It is 5 groups whose expressed interest is in ending all abortion in the United States. These are not people who have gone to this out of an interest in protecting women's health. These are people who look at this as a way of ending a woman's right to choose an abortion, and that's a right that's protected by the Constitution.
First of all, it is the standard of practice, and the fact that our 20,000 plus physicians and other healthcare professionals care for the whole person, the woman and the baby in the womb, shouldn't negate their opinion. What I think Nick is engaged in here is a little bit of ad hominem. The question is not what perspective is one side or the other coming from, because obviously the folks that Nick represents have their own perspective, which is contrary to my clients. The point is, where is the medicine? What is the actual standard of practice? And the actual standard of practice for outpatient surgery is to have admitting privileges. What Nick says is very true. In Texas, there is no legal mandate for other kinds of outpatient providers to have privilege. It's because it's not necessary. They already do. It was necessary to require abortions to do that, to come up to the same standard as other outpatient surgeons. And that's very basic. Finally, I'm glad you mentioned Dr. Thorpe. Dr. Thorpe was one of the experts for Texas. He is extremely well credentialed. He actually is chair of 2 departments at a major public university. And he does go and testify from time to time nationally in support of these abortion regulations. He is as well credentialed as any of the experts on the other side. And when Nick mentions his admitting privileges, he's referring to a passage in the court's decision where the court noted that Dr. Thorpe doesn't actually carry these kind of traditional admitting privileges, but the court also noted that it was unclear that he had other arrangements. He does, in fact, have other similar arrangements to take care of emergency procedures. And so there are different ways of handling this. The fact is that the abortion industry all over the country sends their lawyers out to oppose these regulations, no matter what form they take. For example, some states have passed what are called transfer laws, and they require that simply an abortion provider have a written agreement with another doctor who has admitting privileges in order to transfer and admit the patient to the hospital. The abortion industry opposes even those. Everywhere reasonable health and safety measures are put up by states, the abortion industry is there to try to knock them down in the courts.
Thank you. Thank you very much. And?
Well, Texas also had those same requirements that you transfer a patient. Every single one of these clinics had that same agreement, and yet we're here discussing a law that's deliberately put in to put an extra burden on abortion clinics. The American Medical Association does not believe that these laws represent standard medical practice. The American College of Obstetricians and Gynecologists do not believe that these requirements are standard medical practice. The only people who do believe it's standard medical practice, apparently, are people whose express interest is in ending all abortion in the United States. And we talked about Dr. Thorpe. So let's actually look at what a judge said about Dr. Thorpe when he testified in Alabama in the Strange case. His testimony was dismissed by the court in there, and Thorpe was said by the judge to display a disturbing apathy towards the accuracy of his testimony. I've been in a lot of legal cases back in my for-profit career and in my non-profit career with the Center for Inquiry since. I have never seen a federal judge tear into the credibility of witnesses in the way multiple federal judges have done to the multiple witnesses put up by Texas and other states to justify this law. A disturbing apathy towards the accuracy of his testimony. What that means in non-legal terms, for the non-lawyers in the audiences, the judge said he lied.
In terms of Alabama, I'm glad you mentioned Alabama, because I think that your brief does a good job of picking out criticisms that courts have made of states' experts for abortion. The fact is that there have been criticisms of the abortion industry's experts, including Planned Parenthood experts. For example, in Alabama, the very same judge criticized or refused to credit the testimony of Dr. Paul Fine, who also goes from court to court testifying for Planned Parenthood against abortion regulations. Dr. Fine testified that no hospital would give an abortion provider in Alabama admitting privileges. Well, the court said there were 6 hospitals in the area of this abortion clinic, and he said the testimony from 6 representatives was that all of them went by objective criteria and did not bring politics into the decision whether to give a doctor admitting privileges. So I think you're picking and choosing a bit when you criticize Dr. Thorpe. And the other thing that is going on often is that Planned Parenthood and the abortion industry do something called forum shopping, regrettably. They know which judges are opposed to abortion regulations, and they file in those courts. There are judges in certain courts that are vehemently opposed to abortion regulations, and when they get a chance to sink their teeth into a state's experts, sometimes they do it with relish, and I think that's what's going on here.
When we come to admitting procedures, it's the same old faces, the same old witnesses every time, and every judge that they have been up before to justify the unjustifiable, frankly, to justify these admitting privileges requirements, has turned around and said, you know what, I'm discounting your testimony.
All right, we're going to take some questions from our viewers. The first is from a Willard Curtis, and he asks, how do these regulations differ from restrictions on crisis pregnancy centers? How do these regulations differ from restrictions on crisis pregnancy centers? Sure. Hypocrisy, anyone?
Well, we represent a lot of pregnancy resource centers, they're called
right.
now. CPC is an old term. In fact, today there are 5 times more pregnancy resource centers in America as there are abortion clinics. And that just shows you who cares more about women. But the point is that most pregnancy resource centers are charitable organizations. They offer ultrasound, they offer STI testing, and they offer pregnancy testing. They're not doing surgery, and so they are not subject to the same rules and regulations as surgical facilities like abortion facilities. So it's really a question of apples and oranges.
Do they offer anything for men, for the men?
Oh, many of them do, yes, many of them do.
What, like
counseling, resources to help for women who decide to give birth to the baby, and financial resources, state, public aid, and things like that. Yeah, there's a wealth of resources both to men and women that Pregnancy Resource Centers offers.
Okay, thank you very much. Would you like to comment on that?
Sure. Shockingly enough, we're actually going to have a slight agreement on this, which may be the only one of the night. It is comparing apples to oranges, because crisis pregnancy centers do a very different job. There's one thing they provide that we weren't told about. They tend to provide outright lies to women who are pregnant. They pretend to represent themselves as having a full range of services, and yet they don't. They do not offer abortion. They do not offer contraception. In fact, in California, there's a law being put forward to require crisis pregnancy centers to say, we don't provide these services, and these services are available at these hospitals. Guess who's fighting that law? The exact same religious right groups that want to end abortion. These clinics, crisis pregnancy centers, obviously shouldn't be subject to the same restrictions as abortion clinics, but they also shouldn't be allowed to lie to vulnerable pregnant women, often minority women, often low-income women.
From Amy Scott, and she asks, if a dentist's office can't abide by health regulations, should we lift the regulations so the office can stay open? Go ahead.
That is an interesting question. Definitely on it, no. We shouldn't, as long as the restrictions are not putting an undue burden on your ability to go to the dentist, although interestingly, going to the dentist isn't a constitutional right. But in particular, the regulations on a dentist, just like the regulation on an abortion provider, should be shaped to the procedures that are provided there. The mortality rate for dental surgery is the same as the mortality rate in the United States for getting an abortion. The number of people who die while they're getting it, as per 100,000 people who do this. Same mortality rate. And we're not seeing the Alliance Defending Freedom bringing lawsuits demanding that a dentist's office meet an ASC standard. They're not demanding that a dentist hold admitting procedures.
When clinics shut down, by and large, it's because they can't abide by general health and safety standards. And so you see in Texas, let's take another state, Mississippi. There were 7 abortion facilities in Mississippi about 20 years ago. One by one they closed. One of their operators ended up going to jail for child molestation. Another was shut down by the state for horrendous practices. And so one by one they all shut down, except the last one in Jackson. This one allegedly hired a doctor who was legally blind, who's had multiple lawsuits filed against this center, and whose owner was ordered by the state of Alabama, where she was previously, not to own any more abortion facilities because she'd run afoul of the law so much. That's the state of abortion in Mississippi. And yet a federal judge ordered that that facility must stay open for access because it's the only one left in the state. What some of these judges, and what I think Nick unintentionally is arguing for, is a constitutional right to an unsafe abortion. And that's just not something that we should tolerate.
It's time for Answer This, where each guest asks a question directly to the other. And who would like to go first?
I'm happy to, or would you like to?
Go ahead, please.
Sure. Okay. And again, it's going back to your organization's express belief in a fetus having full human personhood from the moment of conception. And you in your brief claim that you are here supporting women's health. How is it plausible for you to make this claim that your support for these regulations is based on making abortion safer for women? You view abortion as murder, and yet you seek to make participation in what you view as murder safer. Are there other things you view as murder that you would try and improve the safety for the participant in it?
Well, Nick, we do believe that that abortion is, in the words of Justice Kennedy in one of the abortion cases about 10 years ago, a grave moral evil. But we also believe that you have to take the legal rules as you find them. And what the Supreme Court said in both Roe and in the Casey case in 1992 was that even assuming that women have the right to access abortion under the Constitution, states have the authority to make those conditions as safe as possible for women. And what we're seeing is women dying in abortion clinics across the country, in places like Chicago, where a woman died of an abortion 2 years ago. In one clinic in Alabama, twice in one day, women were transported to the hospital. As I said, in Texas, the parties agreed that over 200 women every year are taken to the hospital for emergency circumstances.
Did you have a question for Nick?
I do.
Go ahead.
You know, you talk about science a lot, and one thing I can't agree with you totally on is that both court decisions and the practice of medicine should be based on good science. One of the most eminent embryologists in America, Dr. Bruce Carlson, was an expert for us in a case in South Dakota a number of years ago.
But your question.
Yes, he wrote the seminal textbook on embryology. He gave the opinion to the court that the fetus in the womb is a human being. He said that was a factual disclosure the state required because the fetus is a member of the species Homo sapiens. Let me ask you, as a scientist, can't you agree with Dr. Bruce Carlson, the eminent embryologist, on that point? And if you agree, if you admit that, don't you agree that if the fetus actually is a human being, that we owe moral and legal duties to human beings in the womb?
I'm not a scientist. I've never made the claim to be a scientist. I actually have not studied science since I was 16 years old. But as a lawyer, what I do understand is that the Supreme Court has weighed these issues and believed that there are two sets of rights which a state considers. The state is allowed to have an interest in what they call the potential for life. They also have to consider the rights of the woman concerned. And to claim the idea that a woman who may have been raped, a 12-year-old girl who may have been forced into sexual activity by her father or stepfather, a woman who's forced to live on the streets and engage in sex work and who has become pregnant in that manner, a woman who has a child, a fetus growing, a wanted fetus, someone who wants to get pregnant, who discovers that that fetus will never come to term. will die, that their rights matter nothing to the anti-choice people. They matter nothing at all. I want to stand up here and say, no, we actually think a 12-year-old girl raped by her father has the right to turn around and say, I should not be forced to carry this baby, this fetus to term.
Okay. And now it's time for We Agree, where each guest names something the other said that they agree with. So who would like to start?
Well, I will, if you don't mind.
Okay.
I'm responding to Nick.
All right.
Nick, I totally agree that the practice of medicine should be based on science. Where I think we disagree is you can't put the practice of medicine in a test tube. You can't subject it to the scientific method. The evolution of the practice of medicine has come about after many, many years, and as our brief on behalf of 20,000 plus healthcare professionals has informed the court, the standard of care for outpatient surgery like abortion and other similar procedures is for the physician to follow up, take care of the patient, do it in an emergency room if necessary, and do all of that in an environment of an ambulatory surgical center facility. Okay. So, yeah, we totally agree.
I can find something I agree with, I'm sure.
Okay, okay.
I agree with you when you said that the rate of abortion has dropped in the United States. It has, and let's look at why it's dropped. Okay. It's dropped because of comprehensive, effective sex education programs in our schools. It's dropped because of the availability of contraception, things which Mr. Ada opposes and is seeking to take away. In areas where these laws are put into place, the abortions become later in term, they become more expensive, so women can't afford them, which may cause the rate to drop, and they become less safe because they're later term abortions, and you see a massive spike, as we're seeing in Texas today, of self-administered abortions.
Gentlemen, that's all we have time for. We'd like to thank Stephen Aden of Alliance Defending Freedom and Nicholas Little of the Center for Inquiry for joining us to discuss this case. And thank you for watching Scholars Mate. I'm Judy Grill. We'll see you next time.